Hi there. My name is Tom Goldstein. I'm the publisher of SCOTUS blog, and thanks very much for coming to our program on the Barr versus American Association of Political Consultants case. This is one of a series of programs that the blog is doing to try and use the telephonic oral arguments that the court is holding for some form of educational purpose. Today we have the first of the telephonic arguments in the Booking.com trademark case, and I thought it went remarkably well, particularly for the court's kind of first attempt at something very, very different for it that it doesn't have any experience with. That's true both with respect to having telephonic arguments and also live streaming the audio. Today, we're going to focus on this First Amendment case and talk about what the issues are in the case and also kind of where the case fits in broader doctrines about the First Amendment and to some extent maybe about severability. And Amanda Shanor is going to introduce the case for us. Amanda.
Terrific. Well, first, it's wonderful to be here with you all today, Tom and Genevieve, and to all of you listening out there in cyberspace. So as Tom said, I'm Amanda Shanor, talking to you from my house. I am also an assistant at the Wharton School at the University of Pennsylvania, where my research focuses on constitutional law and the First Amendment. But I also want to give a shout out to my really wonderful group of 1Ls that I'm teaching Con Law 2 this spring. Okay, so a little bit about this case. This case, as Tom said, is one of the 10 exceptional cases originally scheduled for oral argument earlier this spring that's now going to be heard by telephone, by the justices by telephone, and that we can all listen into on Wednesday morning. So this case is about robocalls, and specifically the case is about whether or not the federal law prohibiting robocalls to cell phones violates the First Amendment's speech clause. What's important about this case, I think to begin with, there are three really important things about this case, and then I'm going to tell you a little bit about it, its history, what happened, and then hopefully get into, with Tom and Genevieve, the larger importance of the case. But it could have a significant impact on political advertising in the run-up to the 2020 election. It could also have really big impacts well beyond robocalls to the constitutional rules around both commercial advertising, but also the bigger questions about sort of like content neutrality rules, which are the larger doctrinal structure of the First Amendment. And then also, as Tom said, about severability and the rules around when and why a court sort of responds to when part of a statute is found to be unconstitutional. Okay, so three big issues, I think, and I guess I'll say then a little bit about the act in question and the procedural history and the arguments made by the parties. Okay, so the law at issue is the Telephone Consumer Protection Act of 1991, which what Congress passed out of widespread outrage about robocalls and telemarketing. The act prohibits what are called automated calls, which are calls made by an automatic telephone dialing system or that use an artificial or pre-recorded voice to cell phones. And what's important in the act are actually the exceptions to the general ban of using robocalls to call cell phones. And there are now three big exceptions. Two of them were originally in the act, and they're for emergency calls and those made with the prior consent of the person called. But in 2015, Congress amended the law to add a third exception, which is really what's at stake in the case, for calls made to collect a debt owed to or guaranteed by the federal government. So essentially what's happening here is that a group of political consultants are bringing suit against the law on First Amendment grounds. The group includes political fundraisers, pollsters, and basically a group of political consultants who are trying to use robocalls to persuade and inform voters, to do political fundraising, and to organize voter turnout efforts, again, in the context of the 2020 elections. They're challenging the law on the grounds that it is, quote, content-based, which, as we'll discuss, is a First Amendment doctrine that refers to when a law applies differently or at all, depending on the content of expression. And generally speaking, as we'll talk about, laws that are content-based get strict scrutiny, really heightened scrutiny, as opposed to ones that aren't. Okay, so what the consultants are arguing is that the Act's third exception, the one about collecting government debt, makes the law content-based, and therefore strict scrutiny should apply. And the law, they say, under that strict standard can't survive. Essentially, the district court and the Fourth Circuit did apply strict scrutiny, but for important purposes here, the Fourth Circuit found that the government debt exemption did violate the First Amendment, but it didn't strike down the entire robocall cell phone ban, and instead it severed the exception from the rest of the Act, leaving the general cell phone robocall ban in place. Tom, do you want me to say more about what the parties' arguments are at the Supreme Court level?
Well, why don't we bring Genevieve in, and then you can fill in additional detail from there.
Great.
Okay. So maybe you just say a little bit more about the sort of this question about content-based, whether it is and what's at stake here. So part of the complicated nature of this case is that the TCPA was enacted quite a long time ago, and then there was this additional government debt exception that was added to it. And at the time it was enacted, the rules governing what counted as content-based lawmaking, subject to really, really strict scrutiny, it's very hard for content-based law to survive constitutional scrutiny, they were pretty lax. The court had a long line of cases in which it said, well, so long as the purpose of the regulation is to do something other than restrict speech because the government doesn't like its viewpoint or its message or its subject matter, we're going to treat the law as content neutral. And so there's a whole line of cases dealing with this statute, the TCPA, up until 2015, that almost uniformly, I believe, conclude that it's content neutral, because the government's not doing this in particular to go after any group of speakers. It's trying to protect privacy. It's trying to prevent people from getting a bunch of annoying phone calls on their cell phone, especially when it costs you money, right? There are very legitimate non-censorship kinds of reasons why we might want to ban these kinds of robocalls. They are super annoying. They maybe take up space that would be better used by non-robocalls calls. And of course, remember, these robocalls can be completely legally made so long as an actual human being makes the phone call. What the government is trying to prevent is these very cheap ways of disseminating what are often received as like really unpleasant or annoying phone calls by using robots or using electronic means. Okay, so up until 2015, there was just really, the statute is understood to be totally fine within the First Amendment. And then in 2015, the court hands down this decision, a kind of important decision called Reed v. Town of Gilbert, in which it revises its understanding of what counts as a content-based law and says that, no, laws are content-based, not just when the government has a kind of content-related purpose for enacting the law, right? It's not only content-based when the government is enacting the law because it doesn't like a particular message or viewpoint or speaker. Laws are content-based whenever they are distinguished between speech based on its content. And so if you have a law that restricts someone from saying, I like apples, and a law that, but it doesn't restrict someone from saying, I like oranges, that's content-based. And so after 2015, courts now faced with this question of whether the TCPA exemptions or the TCPA in general is content-based, start to reach a very different conclusion. And so this is the world we're living in now, where we're seeing the effects of this decision Reed on the First Amendment landscape, on the statutory framework dealing with speech. And in this case, I think correctly, I'm curious what Amanda thinks, but correctly, both the the District Court and the Fourth Circuit found that this is a content-based law, because when the government makes a phone call to collect a government debt, the only reason that the law prohibits that doesn't prohibit that robocall, allows it, is because the subject matter of that call is a government debt as opposed to a private debt. And that seems like a very characteristic content-based distinction. And even if we think that the government has legitimate reasons for making this distinction, it's no longer considered content neutral. It's now considered content-based under the First Amendment. And it's hard for me to imagine that the Supreme Court is going to disagree with this conclusion when it hears the case. What do you think, Amanda?
Yeah, so first I'll say, Genevieve captures what the consultants argue, right? Essentially, like, what the TCPA does, it allows calls that are about collecting government debts. It doesn't allow any other type of call. Well, other than the other exceptions, it doesn't allow any other types of robocalls, which includes really core political speech, right? You can't have a robocall to, advise somebody about who they should vote for president. And that's at the core of what the First Amendment cares about and protects. And for that reason, strict scrutiny should apply. What the government argues in response is this is not actually a content-based restriction because, and they give this, I think, really vivid example. They say, what if there's a robocall and it goes to two different people and it says the same thing, please submit, you have a debt, please, submit your payment. The content of the call is the same, but one could be a permissible call under the act and one would not be, not because of the content of the call, but because of the economic relationship between the government and the debt. So basically whether or not the debt is backed by the government, and that's not content-based, that has to do with a background economic regulation. I see Genevieve is shaking her head.
Not a good argument.
That's the government's argument that they say that's why the law isn't content-based and should receive less stringent scrutiny.
Okay, but that's a bad argument because that's trying to pass what is, and this is part of the complexity of what counts as content-based, but the government is trying to distinguish between like the words you use. The words can be the same from this thing I call economic relationship, but we might think that content means semantic content, like what do the words refer to? Mm-hmm. And so we might think that in fact, even though the words are the same, the actual English words you use, the semantic content of the words is different because in the one case, the word is referring to a government debt. In the other case, the word is referring to a private debt. And so we have a classic content-based distinction because we're distinguishing between one speech act that has a particular semantic content and another speech act that has a particular semantic content.
No, and there's broad language in Reed that can be referred to that what content means is topic or subject, right? Mm-hmm. And so that really we should understand Reed to be about exactly what you're talking, semantic meaning as opposed to the particular words. So I agree with you that it's not, that there's weakness to the government's argument, but I think part of what's at stake here is how we should think about Reed. And so for those of you who don't know, Genevieve has written a fabulous article on Reed, which everyone should read. You should read Genevieve's article about Reed. But so Reed—
And by the way, and the article does talk about the TCPA and suggests that the TCPA is now going to be one of those statutes that's in trouble after Reed.
Okay. So, but the thing about Reed is that the way that it articulates the test for content neutrality is you could either say a big deal or not a big deal at all, depending on how you understand it. But the big deal idea is maybe it would undo a whole lot of other First Amendment law about content neutrality because a lot of so I teach and write about and litigate First Amendment cases. And one thing you may not know is the First Amendment doesn't apply the same level of strict scrutiny to everything. It applies different levels of scrutiny in a whole lot of different contexts, okay? Which is new to a lot of people, even people who know a lot about the First Amendment. Okay, so a lot of things are content-based or regulations can be content-based that the First Amendment has normally thought are totally fine, including regulation for ordinary commercial advertising. And so if we take Reed literally, it would undo a whole lot of First Amendment doctrine. And the courts of appeals have been very resistant to doing this. And so this case really tees up, as Genevieve says, much broader questions about the Supreme Court sort of like in its interpretation of Reed and how it's going to go forward in structuring the First Amendment more broadly.
And I guess I'll just say, add on to that, to sort of put this in historical perspective, I think one of the difficulties here is that the court, even while it has in Reed embraced this kind of, I think, pretty broad, or at least the language suggests could be really broad definition of what counts as content-based, and also made clear that the standard of scrutiny should be extremely demanding when we are dealing with content-based laws. And so Reed is generally understood, and I think correctly so, to be a very deregulatory decision, meaning it has the potential to strike down all kinds of laws that up until 2015 we did not think were problematic. Although, as Amanda points out, the lower courts have been somewhat resistant to reading it broadly. They've read it narrowly. So, for example, they've excluded commercial speech from Reed, even though the opinion doesn't say anything about being limited only to non-commercial speech. And there are other ways in which the lower courts are refusing to read it quite as radically or as expansively as the court, as the language suggests. And so one might imagine that this is a second bite of the apple the court can either double down on what it did in Reed now that it has this case, or it can go along with a more nuanced approach. My intuition is that it's going to double down, and it's going to take a very a broad approach to Reed. But that doesn't solve the problem, because what the Fourth Circuit did is that it held that even if this government debt provision is content-based, as I think it should be understood to be content-based under Reed, at least if you read the words in the opinion to mean what they seem to mean. The Fourth Circuit said that this exception can be severed from the rest of the law, meaning that the rest of the law is totally fine. And it also means that the petitioners in this case do not get what they want, because they do not care about the government debt exception. They're not debt collectors. They're not harmed by the government debt exception at all. And in fact, if we had more time, we could talk about standing issues in this case, but let's leave that aside. What they want is to strike down the law so that they can engage in political robocalls. And the difficulty about the sort of Reed framework is, even though it establishes this very strict standard for what counts as content-based lawmaking, the court has generally applied a much, much more deferential standard to what counts as content-neutral lawmaking. So the petitioners cannot make an argument that in general the TCPA needs to be struck down, because in general, it's understood to be a content neutral regulation. It regulates the manner of communicating, right? You can't use robocalls, not the content of communications. And under the court's well-established content neutral line of cases, it's totally permissible, even though I think their real argument is that the law it restricts too much speech, it's no good. They can't have a straightforward attack on the law, because if they did, they would have to be dealing with this very deferential standard of content neutrality. And so they're trying to say, no, the problem is not the law in general. The problem is that the law carves out all of these exceptions. And because it carves out these exceptions that are content-based, that invalidates the law in general. The Fourth Circuit totally did not buy this argument. It said, okay, there's this government debt exception that is content-based. We agree with you, but we're just going to sever it. We're going to strike it from the rest of the law, meaning that the rest of the law continues to operate with full force, which is totally not what they wanted. And so that seems like the easiest course for the court to take in this case. It can easily double down on Reed by saying, yes, Reed makes clear this is a content-based exception. But in general, the law is a content-neutral regulation of speech. We're just going to carve out the problematic passage, and we're going to proceed on our merry way. Now, in their brief, the petitioners, the plaintiffs in the case said, you can't do that, because what you're saying is that we've got this really problematic law that has this content-based problem, a content-based exception. So the solution is just to make it apply more broadly by getting rid of this exception. And that seems really bad. We're just going to give the government more power to regulate speech. So Amanda, what do you think about that argument?
Yeah, so I think it's a strong argument. Well, so I think that it's persuasive in some ways. I agree with you, though. I think it's going to be less attractive to the court. Okay, so basically what the consultants argue, right, is that the solution, if you're challenging a content-based law, so generally speaking, you have a content neutral law that has like an exception that makes it content-based. The court can't just like take out the exception and still be banning all this speech, because then what would happen would be that essentially the petitioner, the person challenging the law, wouldn't get any relief. The ban would apply more broadly, and that can't be what the rule is. And I think that there's something persuasive about that, but I agree with Genevieve that I think the court is going to be attracted to the idea that we can just fix everything, and by taking away the exception, in part because, otherwise we're going to have a lot of robocalls to everybody. And I think, that backdrop is maybe not lost on the court either.
Can I mention one thing about that? And that is, we have one question that tees off on the effect of having all these robocalls and how this law is perceived and how much people hate robocalls. And that is, do you think that the fact that the election is coming up will have any consequence for the case, or just in general, whether public perception of robocalls will affect the justice's views of the right answer here?
So I have no inside knowledge. This is completely speculative, but you could imagine it going both ways. So on the one hand, the fact that the election is coming up and there's going to be tons of political robocalls if the statute gets invalidated, it certainly raises the stakes of the case. It might lead the court to think, okay, we don't want to make this major revision to the law of political communication right now, and also perhaps might seem partisan in some way. But on the other hand, it might only make it more salient to the court the fact that the statute really is restricting a lot of what is usually considered high value, central, core First Amendment speech, political speech. And so I guess my intuition is the latter, that in fact, the fact that we're so close to the election is going to make the court more loath to uphold the law than it would otherwise be. Although, of course, the easiest route is simply the severability analysis. I don't know, Amanda, thoughts on that?
Yeah, I agree. I mean, I think that the context of the election is going to make the court feel like it's all the more important that we hear this type of speech. And I think, one of the questions that I've had is whether or not there's any possibility that the court will say, well, as applied to political speech, this might be constitutionally problematic, and we'll leave for another day the broader robocall ban for other types of robocalls.
But see, if they do that, then they're carving a content-based distinction into the statute, which under Reed, they're really not supposed to be doing. So I think there is a way in which it does feel a bit like we're doing shadow puppets here. This is, much of the argument has been about the government debt exception, but nobody in the case, none of the litigants involved, the government, but the plaintiffs in the case do not care about the government debt exception. They care about the political speech aspects. But that's difficult to get to because there's no argument that there's a content-based exception related to political speech. And so really the argument I think they want to be making is that this is an impermissible content-neutral regulation of all speech that happens to impede too much their ability to engage in core political speech. But that's difficult for them to do. They're not even trying to make that argument because they know, I think, that they will lose. The courts are going to find that it's legitimate for the government to try and protect people's privacy. This is a reasonably tailored means of doing so because you can make phone calls yourself, you just can't use robots. And so they're out of luck there. And so I am curious to see how much the court, rather than revising its content neutral precedents, which it's not going to want to do, and it hasn't been asked to do that, how much that's going to influence its dealing with the case, whether it's going to think the statute is problematic, not really for doctrinal reasons, but just because it genuinely is restricting a ton of speech. And so be more likely to side with the petitioners. Just to go back to one thing you said earlier, Amanda, the petitioners make this argument like it'd be crazy to sever this exception because how insane to think that the relief will be to make the law apply more broadly than apply more narrowly. But there are a line of First Amendment cases in which the court says, it's funny, but sometimes the constitutional problem with a law might be that it's too narrow rather than it's too broad. We think that surely the First Amendment always prefers the government to restrict less speech rather than more speech. But the court really wants the government to be even-handed in its regulation of speech. And so sometimes statutes can fail under the First Amendment because they're too broad, they sweep too broadly, but sometimes they can fail because they only target certain speakers or certain kinds of speech for restrictions and not others. And so the government, in arguing for severability, it says, this exception is content neutral, but even if it isn't, it should be still severed. It's not the first to make this argument, and in earlier cases, the court has agreed with it.
The other thing the government points out, right, is generally speaking, the touchstone for severability analysis is to ask what Congress would have intended, right? Mm-hmm. And so they point to the fact that the law has a severability clause, right, that says if one provision is held invalid, the remainder shouldn't be affected, right? And the government also points to the fact that for this long time period between 91 and 2015, Congress preferred a content neutral robocall ban and didn't add the exception at issue here until 2015, which is to say essentially the government argues if Congress thought these two provisions, both the ban and the exception, couldn't constitutionally coexist, then they would have chosen to protect people against robocalls more broadly. And I think that that's really compelling. The other thing I want to connect it to is the fact that we have a large looming question about severability in the Obamacare case, about the severability of the individual mandate. And I think that that will be, potentially at oral argument, we'll see questions about severability that are in some ways pointing to that really high stakes question. In this earlier sort of like a little bit smaller context.
Before we run out of time, though, I just want to bring in the one final thing, which is the secret exceptions issue, the sort of lurking content-based exceptions, because in the briefs, the primary focus of concern is this government debt collection exception, which seems content-based. And the Fourth Circuit said, yes, it's content-based, we can sever it, but it's just one. And as Amanda pointed out, it's a latecomer. It was added on top of this otherwise content-neutral statute. So the severability analysis to me seems super easy if we are only focusing on the government debt exception. But it turns out that there's a whole bunch of what look to me like content-based exceptions that the FCC has enacted through regulatory means. So it's not written into the statute, but it's part of the delegation of authority to the regulatory agency to enforce the statute. And these include things like there's exceptions for government entities calling about official business, healthcare calls relating to identity theft, and I think the most amazing to me, given sort of the very serious stakes of the TCPA, package delivery notifications, which are obviously content-based, because the way you know that this is exempt is it's about the delivery of a package. It's hard to get more content-based than that. And so now we've got like a half dozen exemptions that are also content-based on top of this big content-based exception that is written into the statute. So if you start to factor all those in, it looks like a less clean severability analysis, because now you not only have to get rid of the government debt exception, but you have to say something about the regulatory agency's authority to enact these kinds of content-based rules going forward. Now, the reason these are not really a big part of the way the case is being discussed is because the district court found that it wasn't going to deal with them, because it thought that because this is about the sort of power of a regulatory agency, it had to go through other channels. And so they've fallen out of the case. But the petitioners bring them up in their brief. They're scattered throughout. And it is part of the context. And so I'm curious whether they're going to make a reappearance at the oral arguments, or whether they're going to factor into the court's opinion. Because if we are making a judgment about the content-based or content-neutral nature of the statute overall and how problematic these exceptions are, it does seem strange to me to focus only on the government debt exception rather than these other exemptions.
I don't totally disagree with you, Jen. I mean, I think it'll be interesting to see whether or not that's raised at oral argument, but I want to push back a little bit on your sort of like interpretation of Reed. I think, and this idea that like, of course, all of these things are content-based and therefore, they should all be struck down or get strict scrutiny. And I think that one of the questions here is whether or not that's going to be the course that the court takes, right? Because I think there's a way in which Reed is written very broadly, and that could be deliberate, or that could be in some ways unintentional, given it's very specific. So Reed was this case from 2015, for everybody who don't know. It was about signs and the types of, this town of Gilbert had all these rules about the types of signs you could post and when and why and how. And the court says that's content-based and sort of has really broad language. But that broad language, again, would unsettle a whole bunch of First Amendment doctrines. And I think there's a way in which, I think, Genevieve, you're like, well, of course it's going to double down, but maybe not, because you could also say the court normally doesn't, as Justice Scalia always says, like hide elephants in mouse holes, right? You could think the court didn't really mean to overrule tons of other cases sub silentio. And I think that this case tees up whether or not what really the court meant to do and read and what directions it's going to go.
Can I make? Oh, sorry.
Yeah.
Go ahead, Genevieve.
Well, I was just going to say, I mean, that's perfectly plausible. My intuition is that's not the direction the court's going to take, but also the facts of Reed are really problematic. I mean, the sign coded issue in Reed had earlier been phrased to target religious organizations or churches in particular. There was all this sort of religious animus swirling around in the facts of Reed, which the court really was worried about. And so one might imagine, yes, that the broad language in the opinion is a response to the really bad facts of the case. And there's no evidence of that, of any of that here. And so maybe the court is going to reread Reed. Nice. But I think it's hard to get away from the sort of the, unless the court really wants to revise Reed. So, there's lots of cases, for example, maybe the government debt exemption, where at least you can make a plausible argument. I don't think an ultimately convincing argument, but a plausible argument like the government does here, that this actually isn't a content-based restriction under Reed. But the package delivery notifications, I guess you could say, you could say your package is coming, but in one case you're joking, in the other case you're not, and it's about the economic relationship between the. I mean, I suppose you can always get out a read. Sure. Okay, Tom.
Oh no, thanks so much. All right, well, I think our timing is perfect. Let's call it at this point. We hope that everybody who watches this and live stream with us today will listen to the oral argument. And then we have scheduled another program to come back and recount it and recap it and see how on point your predictions were. And we'll only remember the correct ones. But thank you all so much. I learned a lot about the case and about doctrine today, and look forward to seeing you all again in a few days.
Okay. Bye, everyone.
Thanks.
Wonderful to see you.